Hey everybody, we are back. It is Help Solve the Case. I'm Christine Burke, and we are following up on the order issued today in the Luigi Mangione case, suppressing some evidence. Now, if you haven't seen the first video, I went over everything that the defense was claiming, what they were asking the judge to reject from purported alleged improper police procedures. And Luigi Mangione, however you want to look at this, won some, lost some. And that video was very lengthy, going over everything that the defense team was arguing and asking for. And here we have the judge's decision and order hot off the press. So let's get into it and let's see what is happening here. On December, this is Judge Carro, okay? This is what he's saying. So he says, on December 4th, 2024, Brian Thompson, the CEO of United Healthcare, was shot to death outside the Hilton Hotel in Midtown Manhattan. On December 9th, 2024, the defendant was arrested at McDonald's in Altoona, Pennsylvania, after he was recognized by employees who had seen media coverage. A 9mm gun was recovered from the defendant's backpack, as well as, among other items, a loaded magazine, a silencer, cash, a passport, and a notebook. Defendant has moved to suppress the evidence recovered, as well as statements made to law enforcement officers during and after his arrest. And yes, there is full commentary. We get into all of it. I give you my police insight, my law enforcement expert background in general, going through all that, what they did and why from my law enforcement perspective. If you don't know me, welcome to the channel. I'm Christine Burke, retired detective and sergeant, and I am a law enforcement expert and forensic genetic genealogist, and I love going through these documents, but more so, I love having you guys here. It really warms my heart when you tell me that you love my explanations about the what and the why and trying to make sense of all this. So thank you, thank you, thank you. Your continued support of this channel helps me so that I can get monetized and be able to donate funding to do my forensic genetic genealogy work and my investigations to support those police agencies and those families that do not have it. So thank you, thank you, thank you. I really appreciate all the support. Okay, so getting back to it. The defendant, this is the judge speaking, the defendant has moved to suppress the evidence recovered, as well as statements made to the police. And we go into all the what and why and Miranda and all that in the big video. I will link to it. On September 16th, 2025, this court ordered Mapp and Huntley hearings. And maybe I can find the transcript of that. If you want to hear those, if you want to get into the nitty gritty, let me know below. And we'll see if we can do that. It says the hearings were held in December 2025, and the court heard testimony from 17 witnesses, and they filed some written submissions. Okay, so judge says, we're granting in part and denying in part in the findings of fact. So this is what the judge is finding, his facts. I believe it's a he. And I apologize, I don't normally sound like this, but I've got bronchitis. So, and the news broke. So here we go. I'm hacking through it for you guys. So the arrest at McDonald's, and it goes through the whole motion. We go through pictures and different things. The arrest at McDonald's, this stems from Luigi Mangione being stopped at McDonald's and items in his backpack and statements he made during this stop. So, judge says, the facts relevant to the hearing are largely undisputed. Several officers from the Altoona Police Department testified, and their body-worn camera footage was introduced into evidence, which is good. Judge can see for him or herself. On December 9, 2024, the defendant brought food at the Altoona McDonald's and sat in a back area to eat. A McDonald's employee called 911 to report that the defendant resembled the suspect in the Thompson killing. Now, there's a whole bunch that we get into about some statements, allegedly, this is all allegedly, that he had overstayed his 40 minutes eating. Watch that video, take a look at that, right? Because this is the nitty gritty. Or no, this is the overview. That's the nitty gritty. Altoona police officers Joseph Detweiler and Tyler Fry responded to the scene at 9:30 a.m. Detweiler was a 14-year veteran of the police department who was familiar with the videos and news related to the Thompson killing, while Fry was a rookie. I wonder if that was his, what they call your FTO, field training officer. And it says here we've got a subscript, photos or superscripts, and a, what do you call this? Footnote. Photographs, cold medicine. Photographs of the suspect had circulated in the media. Okay, so Fry was a rookie who knew very little about the shooting. Detweiler and Fry saw the defendant sitting at a back table near the bathrooms with a backpack sitting on the floor near his feet and laptop in front of him. So that's interesting. We could not see where the backpack was. I don't remember seeing the laptop. I remember seeing the bag, but it was kind of far away. You know, the judge had the whole video. When the defendant pulled down his face mask upon Detweiler's request, Detweiler immediately recognized the defendant as the New York City shooter. When asked for his name, defendant responded that it was, quote, Mark Rosario, end quote. And when asked for identification, the defendant produced a New Jersey driver's license in that name. While Fry went to verify the license in the NCIC database, Detweiler asked the defendant questions about where he was from and whether he had been to New York recently. Was that Fry that went to verify, or was that Detweiler? We didn't see the video, so I'm not sure. Detweiler then had the defendant stand up and frisked him, but did not find any weapons or contraband. Fry then stood next to the defendant while Detweiler went outside to call Lieutenant Tom Hanley at the station, telling him he was, quote, about 100% sure, end quote. And that's an interesting change of language there. If you're going to watch the other one, that's interesting. That the defendant was the New York City shooter, and asking him to come to the McDonald's. Correct me if I'm wrong, but I thought it was 100% sure. You know what? I'm going to check. Hold the phone. Dun, dun, dun. Tell him he was 100% sure. There you go. Judgy says about, I don't know. Now, Judgy's taking it from the hearing, I'm assuming. I don't know. He could be taking it from the hearing. He could be taking it from the body cam. But we've got 100% sure, and then we got about 100% sure. So Judgy is saying about 100% sure. Okay. Lieutenant Hanley headed for McDonald's along with Sergeant John Burns, Corporal Garrett Trent, and Officer Samuel McCoy. Woo, the team is coming. Detweiler returned to the table, again asking the defendant if he was from New Jersey, what he was doing in Altoona, and whether he had been to New York recently. And if you want to understand why this chain of events is important, you can watch my whole video. I don't know how much of it the judge is going to get into, but we're talking a Mirandized situation here, but we'll see. Defendant said that he had not been to New York recently. He also stated that he was homeless. Detweiler told the defendant that they were, quote, just trying to confirm, quote, his identity, and that he would then be able to leave. Interesting. I don't think we heard that part. Although Detweiler conceded that he had no intention of letting the defendant leave. Again, if you want to know how cops work and why they do what they do, watch the big video. In response to further questions, the defendant said that he was from the, quote, DMV, end quote, area. I don't know what that is. Oh, apparently a reference to the District of Columbia, Maryland, Virginia. Okay. Who knew that? To me, that's where you get your driver's license and your tags. Okay. While Lieutenant Hanley was on his way to the McDonald's, he attempted to reach the New York City Police Department by calling 911. They were probably like, oh my God, we got him. Give me the police chief on the phone. Get me SWAT. Like, he was probably like, oh my God, right? Oh my God. You know how many times in your career you get to make a call like that, right? Alerting the operator that the Altoona police may have located the New York City shooter. Hanley was still on the phone with 911 as he reached the McDonald's, took the Rosario license from Detweiler, and relayed the information from it to the 911 operator. Meanwhile, Detweiler moved the backpack that had been near the defendant's feet out of the way and out of the defendant's reach. As Sergeant Burns and Corporal Trent arrived, Burns asked Detweiler if the defendant had been frisked. Now, we also heard about Mirandized, and Detweiler responded that he had. About a minute later, Officers McCoy and Luke Yeager also arrived at McDonald's and went towards the back where the defendant was seated. Another officer, Corporal Brian Miller, also arrived at about the same time and went toward the back of the McDonald's. Detweiler asked McCoy to stand next to the defendant at about 9:42 a.m. while Detweiler and Hanley spoke outside. Fry, McCoy, and Yeager continued to stand next to the defendant. Hanley testified that he considered the defendant, quote, detained, end quote, at this point. Again, go watch the long video. Very important word right there. While speaking outside, Detweiler repeated to Hanley that the defendant was, quote, 100%, end quote, the person wanted in New York City. So there we have 100% and not about 100%. Burns and Trent joined them outside where they pulled up photos of the suspect on their phones. Inside, McCoy asked the defendant if the backpack and laptop belonged to him, and he responded that they did. McCoy moved them to a table about 9 feet from the defendant. So in the motion, we heard 6 feet, I think. Now we're hearing 9 feet. 2 more officers, Christy Wasser and Stephen Fox, entered the back of the McDonald's about this time. Hanley called the, quote, turnkey, end quote, officer at headquarters and asked him to run the Mark Rosario license through the NCI system. No record was found. So they didn't run this license before they started calling New York. Interesting. Okay. Hanley told Detweiler, because I wonder if it would have come up even valid or if it's a made-up license. That could have been a clue. Hanley told Detweiler to give the defendant, quote, false ID, end quote, warnings required by Pennsylvania law. Interesting. Detweiler then told the defendant he would be arrested for, quote, false ID, end quote, if he gave the police a false name. And he asked the defendant if his name was actually Mark Rosario, to which the defendant responded, quote, no, sir, end quote. And it didn't talk about the required warning in the motion from the defense, which is interesting. And, we're talking about Miranda and stuff here. Okay. At about 9:48, or fake ID, let's see. Number 3, asked by Fox why he had lied. The defendant replied, clearly I shouldn't, quote, clearly I shouldn't have, end quote. And again, this is allegedly. Asked again by Fry why he had done so, the defendant replied, quote, that's the ID I had in my wallet. I had a fake ID, end quote. Okay. About 9:48 a.m., Corporal Trent directed Fox to read defendant Miranda warnings, and Fox did so. When Fox asked the defendant if he wished to speak to them, he shook his head, also stating, quote, no, I don't think, end quote. Fox told the defendant he was, quote, not in custody at this point, end quote. Let's see what Judge says. Fox continued to ask the defendant why he had a fake ID, and the defendant responded that he was going to, quote, remain silent, end quote. Fox ordered the defendant to stand, frisked him again. Defendant volunteered that he was carrying a jar of peanut butter. When Fox asked if he had any weapons, the defendant first said no, but then stated he had a pocket knife. Sergeant Burns then relayed an instruction to Fox to handcuff the defendant, and he did so. How many times has he been searched now? Where's the knife? Where's the knife? In the peanut butter. After Fox retrieved the knife, he's been searched how many times? Twice? Bad deal. Hanley reached out to the Blair County District Attorney's Office to determine what charges to file, ultimately settling on forgery and tampering. This is number 4. Oh, while Hanley was speaking with the DA's office, the defendant asked McCoy why there were so many officers there, and McCoy replied that they were, quote, just trying to figure it out, end quote. Yeah, because all kinds of stuff applies. I think I'm going to see, if you guys want more, let me know. Hold on. But there's a lot more information in here. I would like to hear those hearings to see what they said. Because there's a lot more information here, which is interesting. Because he was searched. Okay, so a frisk is to make sure there's no weapons. I don't mean to laugh, but that it seems like this is the second frisk, and there's a knife. Okay, so while they're at the McDonald's, they're calling the DA to know what to do. About 9:58 a.m., Hanley instructed the officers to place the defendant under arrest, and Detweiler and Fry each took a defendant by an arm. Wasser began to put on a pair of blue rubber gloves. McCoy confirmed that they were arresting the defendant for tampering, which might be the license, and announced on the radio that the defendant could be marked as, quote, in custody, end quote. Officers Detweiler, Fry, and McCoy searched the defendant's pockets and clothing, recovering the jar of peanut butter, a pouch with money, some coins, gloves, papers, a hat, and some string. As Fox approached the table where the backpack was, he asked the defendant if there was anything in the bag that they needed to know about. The defendant responded that he, quote, was just going to remain silent, end quote. Wasser and Fox then proceeded to search the defendant's backpack. As they did so, employees and customers continued to walk through the back area to access a closet or the bathroom. Wasser unzipped the backpack's main compartment and removed a sandwich as well as a loaf of bread. As they continued to look through the backpack, Corporal Trent approached and suggested that they, quote, go through that back at the station, end quote. Wasser responded, quote, I don't know, just want to make sure there's nothing in there that's gonna blank, end quote. Fox joked that he would rather have a bomb, quote, here than down at the station, end quote. Wasser responded, laughing that she did not want to, quote, pull a Moser, quote, end quote, a reference to an officer that had once transported a pipe bomb back to the station house. Okay, folks, I go into all this stuff in the locker video, but I'm telling you, this stuff happens. This stuff happens. Like, common sense goes out of your head. And this stuff happens. Fox removed a red journal from the pouch and placed it on the table. Wasser recovered a waterproof bag, referred to as a Faraday bag. That's a different type of bag. I wouldn't call that a waterproof bag, but okay. A Faraday bag blocks cellular transmissions and stuff. That's not just waterproof, but that's the judge. Just the judge writing this, okay? Judgy. We leave the judgy, okay? And removed a cell phone, a passport, and a wallet from inside the bag. Fox retrieved a small cardboard sleeve from the backpack and spent some time, if you watch their video, spent some time trying to open it with the knife. He eventually got it open and removed a computer data chip that was inside the cardboard. I wonder if it's a SIM card. Wasser handed the passport to Sergeant Miller and placed the other items back in the bag. Trent and Burns then inspected the passport. Wasser also examined the wallet and took out and looked at the 2 credit cards before returning them to the wallet. It'd be interesting to see whose cards he was using. Wasser removed a pair of underwear from the backpack and unrolled it, revealing a loaded magazine for a handgun. Don't want to be checking them undies. I got stories. Okay. After announcing her discovery to the other officers, Trent stated, quote, now that you've cleared it all, comma, let's just go back to the station, end quote. Interesting. Wasser responded that they were, quote, just making sure it's not a bomb or anything, end quote. Fox told Wasser, quote, now that we found it, the magazine, let's just take it back, end quote. Hanley testified that he then told Wasser and Fox that they should wait until they got back to the station before finishing the search of the backpack because he was concerned about some cross-contamination of DNA evidence. And also because he did not want the search to occur in public. Go figure. Watson and Fox then placed everything back in the backpack except for a few items which were placed in separate McDonald's bag to be taken back to the station. Whose McDonald's bag was it? When asked if they had retrieved a particular item, Wasser stated that they had not completely searched the backpack because they just wanted to, quote, make sure there's no bombs, end quote. Trent then stated, quote, at this point, you're probably going to need to do a search warrant for it, end quote. Corporal Miller agreed. Sergeant Burns and Fox disagreed, stated that they were permitted to do a search incident to arrest. So corporal is below, usually corporal is below sergeant. And who's Fox? Fox is an officer. So Sarge should win. We don't know. It's like tennis. Wasser carried the backpack back to a patrol car to transport to the station while Fox carried the McDonald's bag of items to his car. Now that's interesting because in the motion review, I didn't hear about the McDonald's bag. I'm just thinking about chain of custody. Okay. Altoona Police Department inventory policies, and I go into this in detail in a longer video. Several officers, including the evidence custodian, George Featherstone, testified. And if you want to see those videos, if they're out there, which they may be, about what I think about how this goes, because I am, a law enforcement expert, and I critique on these policies and guidelines and all this stuff. I didn't go through that. That's not in the big video. I just went through the motion. But if you want to know that, let me know. And the relevant APD general orders were introduced into evidence because there's rules, right? It's like the rules of your house, like your mom has the rules of your house. Well, you have the rules of the police department, how you dress, what you do, how you investigate, all kinds of stuff, okay? They're called SOP or general orders. So what the judge is saying here is that APD General Order 3.1.9A subsection 1 requires, must require, and if you violate a general order, you can get in trouble. And depending on the severity of a general order, you get fired. Sorry, guys. Okay. Requires an inventory search of a detainee upon arrival at APD headquarters and before being placed in a cell. General Order 3.1.10A instructs how to properly document and store a detainee's property and requires officers to generate a, quote, itemized inventory of all items taken from the detainee, end quote. Any contraband evidence or weapons will not be returned to the detainee, but would be noted on the property form and documented in the official incident report. What do you think? Is that pretty clear? What is an inventory? What do you think an inventory is? Detainees should be escorted to the APD station house intake area in order for the arrest to be processed. When possible, the detainee's property would be inventoried in his or her presence so as to minimize the claims of theft or damage. Because yes, police get them all the time. They stole money, they did this, they damaged that, However, if the search revealed a weapon, the inventory search would be moved outside of the intake area and away from the detainee. Y'all understand that, right? That's dangerous. Dangerous when people are loose in the jail or people are loose in the room, suspects, detainees are around, no weapons, okay? Cops don't, if you don't know, you have to check your weapon before going into the booking area in the jail. So no bueno there, okay? Every piece of clothing would be searched, as would every bag. Jewelry, extra clothing, and other personal items would be removed and stored. Details, people, right? During the intake process, the officers would determine which items were personal property to be returned and which items constituted contraband or evidence. Okay, so they're getting all this stuff because personal prisoner property is one thing, and then the things that they think might be evidence. Personal property would be listed on a receipt and inventory form and then stored in a locker. Contraband or evidence would be documented, photographed, and placed in labeled evidence. Evidence, chain of custody, all that stuff. Overhead cameras, as well as the officers' body-worn cameras, would record the searches of a detainee's person and property. APD officers were not required to write inventory lists simultaneously, interesting, with the inventory search, but could document the items at a later time. I don't like that. Interesting. Searches at the police station, because Sergeant Burt comes in, right? Like, if I was police chief, what would I do? Okay. Because it's protection. And the reason cops have these general orders and stuff is cha-ching, liability, lawsuits. Cha-ching, 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 cha-ching. When you become a supervisor, even as an officer, but you're like, no suing. Do not get sued. Okay? Once the defendant was brought to the station, or don't get our police department sued, because that's not good for you and your career. Okay, once the defendant was brought to the station, Officers Fry and Austin Homan completed an intake, which involved obtaining the defendant's pedigree information, that's like your date of birth and all that stuff, as well as searching the defendant's clothing. Fry collected the defendant's layers of clothing, his jewelry, which included a USB drive hanging on a necklace, and some personal items such as bus tickets. The USB drive was set aside as evidence while the personal items were collected in a Lowe's bag. Meanwhile, Wasser arrived at the station carrying the backpack as well as the McDonald's bag, which had been handed to her by Fox. Wasser placed the backpack on a chair in the intake area where the defendant was being processed and placed the bag on the floor. She began looking through the backpack, opening a compartment that she had not searched at the McDonald's, and quickly found a handgun. What's supposed to happen now? After telling Deputy Chief Derek Swope about the gun, he had her move the backpack to another room to continue the search. Wasser took the backpack and the bag to an adjoining hallway. As she, quote, cleared the gun, end quote, she discovered it was loaded. She and Swope then placed it in an evidence box. And if you ever want to get yelled at, like, you better take care of your evidence. Like, don't be putting a loaded gun in the evidence, all right? Like, your like, think about your cleanest mom's like worst nightmare about organizing in the house and stuff. Like, you want to get yelled at, okay? You better take care of your evidence, because your evidence custodian will kill you if you, I mean, not literally, but you better make sure that your stuff is all organized and right, because they freak out if it's wrong when they open it. I mean, which you would do. Wasser continued to search the backpack, placing items in separate bags, including items that had been found at the McDonald's, such as the microchip. Okay, so we don't know what it is, microchip. Cell phone and Faraday bag, the knife, the loaded magazine, as well as items that had been found at the station, including a silencer and the USB drive. At one point, she took the red notebook out of the backpack, examined it, and said, quote, "It's like a journal," end quote. When Swope asked if she should, quote, bag it, end quote, apparently suggesting it be treated as evidence rather than personal property, Wasser replied, quote, "I would," end quote. Swope also stated at one point that Wasser should, quote, "make sure there's no explosives in there," end quote. Too late bringing it to the jail, right? We talked about that. Okay. After removing the items and placing them in bags, Wasser asked if she should, quote, "put all this back in," end quote, referring to personal items such as bag of toiletries, batteries, clothing, and masks. An officer agreed that she should. Nobody knows what they're doing here, apparently. Everybody's asking questions of everybody. And Wasser placed the items back in the backpack. I don't know what the 5 goes to. Okay. All of the bagged evidence and envelopes, as well as the personal property of the backpack, was later transferred to Featherstone. Okay. All the property. Interesting. Meanwhile, Lieutenant Hannity spoke with NYPD Detective Lanardi, Manhattan South, homicide, stated he was on his way to Altoona. asked that nobody speak with the defendant. Too late. They already asked the questions. And he was Mirandized, which is not good for the detective. And I didn't add that in the other longer video. But you don't want to read it if you don't have to. Because what did he do? He invoked. And then you can't get your questions answered. I did talk about doing it the right way. So you're going to be left with squat, and you're driving all that way. You're going to be left with squat because they screwed the pooch and did it. Okay. All right. Wasser returned to the intake area with the backpack. We're saying allegedly. We're saying allegedly. Wasser returned to the intake area with the backpack. It was then moved to Featherstone's office, so there would be more room to conduct an inventory search. I thought she already searched it. Sergeant Eric Houston, I don't know how to say that, began photographing items recovered from the defendant, including a Maryland license, a fake New Jersey license, the wallet, the passport, gun, and silencer. He also began photographing loose pieces of paper, as well as some of the writings in the notebook. Houston and Hanley sent some photos of the evidence to detectives in New York. At some point, because Featherstone's office became too crowded, whose office is that? The evidence custodian? Became too crowded? With who? With what? The officers decided to move everything to the roll call room. I have done that. I did that, and I stunk up the whole police. It smelled good, though. It was leather. When I did a counterfeiting thing, it was fake leather. Pleather, I guess you could call it. And I did a counterfeiting thing. And I had it all over the briefing room. I mean, it was bags and bags and bags and bags and bags. And it smelled for days. The chief was so mad. But what was I going to do? I didn't have any room. I mean, we had boxes and boxes when I seized it. We had boxes and boxes. Okay. In the roll call, it's bringing back memories. In the roll call room, Burns photographed every item recovered from the defendant, including every loose piece of paper, as well as every page in the notebook. Burns was particularly careful to photograph where pages appeared to have been torn out of the notebook in order to protect against claims of tampering or damage. Think ahead, people. Lawsuit. See? Lawsuit. Liability. Featherstone packaged and labeled every item and kept a written record of each item recovered and photographed. Application for a search warrant. Later that day, Houston prepared an application for a search warrant for all the items recovered. We could go over that too, because that's probable cause. Listing the items that had been recovered from the backpack and describing some of the information that had been found in the red notebook. Houston also added information about the shooting that had been obtained from Detective Oscar Diaz of the NYPD. Houston described the purpose of the warrant as, quote, to seize, search warrant, search and seizure warrant. Language, to seize the items located during the search incident to arrest and inventory of the property, end quote, okay? Quote, to continue the search of the items, end quote, and to, quote, maintain, end quote, the property to later be transferred to the NYPD. Semantics means word choice. The Blair County District Attorney's Office approved the warrant. It was signed by a Pennsylvania judge. Okay. Defendant's statements. That evening, defendant was arraigned at the Blair County Courthouse on the Pennsylvania charges. On December 10th, 2024, while defendant was housed at Pennsylvania's Huntington Correctional Institution, he was monitored by Correction Officer Matthew Henry. Defendant told Henry that he was a software engineer, that he had been arrested at a McDonald's, that he had been carrying a backpack, and the backpack contained a 3D printed pistol in a magazine, as well as a small amount of foreign currency, and that people were accusing him of being a foreign agent. Henry testified that the defendant, quote, blurted out, end quote, these comments without any questioning from him. Being a corrections officer is still custody type situation. On December 16, 2024, defendant was being monitored by correction officer Thomas Rivers. Defendant talked about his travels and places he had seen in Vietnam and Thailand. He also talked about people appearing to be happier in, quote, third world countries, end quote, despite living in poverty, and they also discussed the healthcare system. Rivers could not recall who initiated the conversation, but Rivers did give his opinion about private versus public healthcare systems. Defendant also asked Rivers how the media was portraying him, and he stated he had heard he was being compared to Ted Kaczynski. Defendant also said that he, quote, wanted to make a statement to the public, end quote. The next day, the defendant spoke with Rivers about books, including discussing his favorite authors and recommending a book by Aldous Huxley. They also discussed the standard of health among Americans compared to Europeans. Okay. All right. Conclusions of law. This is from the judge. So the judge is saying, and what I just read, that's the judge's findings of fact, okay? Initially, this court must decide which state's law, New York or Pennsylvania's, applies when determining whether evidence or statements should be suppressed. Defendant is being tried in New York for a crime that occurred in New York. Under these circumstances, it's clear that New York is the forum state and that New York has a paramount interest in the application of its law. So he's saying that while the people, that's the state, argue that Pennsylvania law should apply as the Altoona Police Department followed Pennsylvania law in, quote, good faith, end quote, that is not the test under New York law, and in any event, New York does not have a good faith exception to the exclusionary rule, People versus Bigelow. Now, that's interesting. That's all. So, in general, what that is if they did it in good faith, you have to excuse the error. Well, whoopsie, they didn't mean to mess up. And sometimes you will jurisdiction shop. So it sounds like they were jurisdiction shopping Pennsylvania versus New York because Pennsylvania would get it in, right? Because the good faith. Okay. The people, that's the state, also argued that the cases cited by the defense only apply where the defendant claimed violations of another state's search and seizure laws because New York courts will not, quote, trouble themselves with asserted violations of other states' search and seizure law, end quote. This court does not believe, however, that those cases can be so limited. The courts clearly state that New York has a, quote, paramount interest, end quote, in the application of its law, and that suppression issues, procedural issues, and evidentiary issues are covered by the laws of the forum state, which is New York. The originating, the court where it's going to be held. The courts do not limit this clear pronouncement, and therefore this court will follow the New York law in deciding the issues involved. All right, so now we're talking about this search incident to arrest. The Fourth Amendment to the United States Constitution protects individuals from unreasonable search and seizures. And he says, the New York Court of Appeals has interpreted it even broader. And they list Jimenez, Goki, okay. To justify a warrantless search, the people must meet two separate requirements. The first quote, imposes spatial and temporal limitations, end quote. So spatial, wingspan, I go into that, and time. To ensure that the search is not divorced in time or place from the arrest. Spatial, yeah. Meaning where it happens. In context of searching closed containers incident to arrest, the second requirement is that the people bear the burden of, quote, demonstrating the presence of exigent circumstances, end quote. We talked about that. In order to invoke the exigency exception, which is, miraculous, speedy, like we got to act now, the property must be within the suspect's, quote, immediate control, end quote, or, quote, grabbable area, Goki. Okay, so that's that wingspan I talked about. In Florida, we called it wingspan, okay? Under those circumstances, there are two interests that justify a warrantless search. Quote, the safety of the public and the arresting officer and the protection of evidence from destruction or concealment, end quote. So he says even a bag within the immediate control or, quote, grabbable area of the suspect at the time of his arrest may not be subject to a warrantless search incident to arrest unless the circumstances, quote, support a reasonable belief that the suspect may gain possession of a weapon or be able to destroy evidence in the bag, end quote. That's Jimenez. That's important. So if you go to arrest somebody on a warrant charge, right? We're just talking through this. I'm not giving an opinion, whatever, but I'm trying to explain this. If you go to arrest somebody on a warrant charge and they have a backpack, are you allowed to search it just incident to arrest? Because he says here that they may gain possession of a weapon. So do you think there's a weapon in there? Or be able to destroy evidence. So on a warrant charge, what's the evidence? Nothing, probably, right? And so are they acting, hinky or whatever, that you think that there's a weapon? Right? Do they have a past the weapons charges? Can you see the outline of a weapon? Okay. Search into safety and evidence. Okay. He says here, the backpack was not within the defendant's immediate control or, quote, grabbable area, end quote, at the time of the arrest or search. Hanley moved the backpack away from the defendant and out of his reach shortly after he arrived. While a number of officers stood around the defendant, Hanley considered him, quote, detained, end quote. A short while later, McCoy moved the backpack to a table about 9 feet away from the defendant, while officers continued to surround him. Once defendant was arrested for false identification, he was handcuffed and remained surrounded by several officers. Hanley was not concerned that the defendant could reach the bag while rear cuffed, hands in the back. McCoy was also unconcerned, testifying that the defendant was surrounded by officers who had, quote, good body positioning, end quote. Okay, so again, if you want us to go through the hearings, we can do that because we're missing a lot of the context here. The defendant was also cooperative, described by several officers as, quote, compliant, end quote, and not, end quote, not combative, end quote, and offered no resistance to the frisk or the placing of the handcuffs. Under these circumstances, the backpack was not in defendant's control or grabbable area. Indeed, the backpack was within the exclusive control of the police. Even if the backpack could be seen with the defendant's control or grabbable area, the people, the state, did not meet their burden of demonstrating exigency, meaning the people, the cops, they work for the people, the state. The people assert that the police were merely searching for explosives. Watch the eyebrows. Mine. In an effort to protect themselves and the public before removing the backpack to the station. However, this justification for searching the backpack does not hold up to scrutiny. The officer's actions, this is the judge talking. It's the judge talking. It's not me talking. It's the judge talking. The officer's actions were inconsistent. That's in trouble. When the judge nails you, you're probably going to be in trouble in your department. You may get fired. You may get fired. This is the judge talking. Okay. The officer's actions were inconsistent with merely performing a safety search. The area where the police searched the backpack was open to the public and employees, both of whom passed by the area on their way to the bathrooms, and in the case of employees to gain access to storage closets. A, quote, safety search, end quote, for a possible bomb is inconsistent with this unsafe protocol. Moreover, the police stopped searching the backpack once they found the loaded magazine. Officer Fox even stated that now they had found the magazine, quote, let's just take it back, end quote. Similarly, if it was a search for a bomb, it was an incomplete one as they left compartments unopened and untouched. Moreover, a search for explosives would be inconsistent with the examination of small items where a bomb would be unlikely to be found, such as the defendant's wallet and the close examination of and opening the cardboard sleeve. This court is unpersuaded that the people have met their burden of showing exigent circumstances. Because remember, it needs a warrant, it needs a warrant, it needs a warrant, it needs a warrant, always, except in an exigency. The people also argued that the search of the backpack was justified because the officers had reasonable belief the bag contained an operable gun. However, while the body-worn camera footage showed that officers did express concern at the scene that the backpack might contain a bomb, there was no evidence that a gun was a concern or that it was the basis for the search. Whoopsie. But even if it were a legitimate concern, there was no possibility at the time of the search that the defendant might retrieve a gun from the backpack, thus no exigency. He says, nor can it be that whenever a gun is alleged to have been used that the police may conduct a warrantless search of a closed container without reasonable belief that the safety of the officers is threatened, as that would, quote, run afoul of the Court of Appeals jurisprudence and would eviscerate the grabbable area doctrine, end quote. Therefore, says the judge, the evidence found during the search of the backpack at the McDonald's must be suppressed, including the magazine. Whoo, I just got like chills. Magazine, cell phone, passport, wallet, and computer chip. And I don't know what was on those. But it's not the gun. Too bad he didn't have the gun in his backpack. I'm saying, the alleged suspect, if the gun was in there, the gun would have been gone. It sounds like he had it in his jacket. Maybe. I don't know. We'll see. All right. Inventory searches at the station house. Okay. So first it was search incident to arrest. Then it became this inventory search. So the inventory search is a, quote, search designed to properly catalog the contents of the item search, end quote, and it must be, quote, conducted according to a familiar routine procedure, end quote. It must not be a ruse for, quote, general rummaging in order to discover incriminating evidence, end quote. 1990, Florida versus Wells. While the discovery of incriminating evidence may be a consequence of an inventory search, it should not be its purpose. An inventory search procedure must be designed to protect the property of the defendant. It's an inventory, like an inventory of your sock drawer or whatever. Protect the police against any claim of lost property, ching lawsuit, and protect police and others from dangerous instruments. Quote, reasonable police regulations relating to inventory procedures administered in good faith satisfy the Fourth Amendment, end quote. And minor deviations from procedure will not invalidate an inventory search. Here, it is clear the Altoona Police Department had an established inventory search protocol that was set out in its written rules and regulations that met the three objectives and sufficiently limited the discretion of the searching officers. The people also demonstrated that the Altoona officers, quote, conducted the search properly and in compliance with established procedures, end quote. Let's see what Judge says. Ooh. Oh, we've got a 6 here. We got, let me see. 6. Let me go down here. It says the red notebook will not be suppressed as the officers did not open or search it at McDonald's. Okay. And here, the search of the backpack was consistent with the written. So when they did the inventory search, it appears he's saying it's consistent. So now he's saying the defendant was first brought to the intake area to be searched and processed according to the protocol. After Wasser arrived at the location, she placed the backpack on a chair in the intake area. Also, according to APD protocol, the detainee's property should be searched in the detainee's presence, so she was trying to do that. Once she quickly found the gun, she moved it to a separate area required by protocol, and the search moved out of his presence. Once Wasser moved the backpack to a hallway area, she continued to sift through it, placing personal items back into the backpack and putting other evidentiary items in manila envelopes, including items found at the McDonald's, such as the gun magazine, the cell phone, and the knife, as well as items found at the station, including a silencer, the USB drive, and the red notebook. This was also consistent with APD protocol that personal items be separated from evidence or contraband. All the items were then moved to Featherstone's office so there would be more room to complete the inventory. This initial inventory sufficiently complied with the Altoona procedure to be valid inventory search, okay, because it's got to match the policy. While Wasser did not prepare a written list of the items, APD policies did not require documentation to be simultaneous with the search. And all the items were documented once they were moved to Featherstone's office in the larger area of the roll call room. Minor deviations from procedure will not invalidate an inventory search. Once the items were moved to Featherstone's office and then the roll call room, all items were meticulously documented. Featherstone, Houston, and eventually Burns placed each item in an envelope, labeled each envelope. That's some inventory search. I'm telling you, somebody got a call because I've never done an inventory search like that. Okay. I'm just saying, like, generally, I'm not saying that would be crazy. This is the judge saying they placed each item in the envelope, labeled each envelope, kept written list item. They photographed each item, including each loose piece of paper and each page of the notebook. I'm going to have to say that is a very, very thorough inventory search. Very thorough. And I would be surprised if every inventory search was done that meticulously. I'm just positing. Thus, it is clear that the Altoona Police Department had an established inventory search protocol, that the protocol was followed, and the search produced the, quote, hallmark of an inventory search, a meaningful inventory list, end quote. And as noted above, any, quote, minor deviations, end quote, from the protocol do not invalidate the search. It says, nor is this court persuaded by the defendant's argument that the protocol only permits inventory searches of defendant's person rather than his property. Yeah, no. Okay. Therefore, the people met their burden of establishing that this is a valid inventory search. Defendant also argues that Washer's brief examination of the notebook to determine whether it should be treated as evidence and Houston and Burns' photographing of its pages were an unlawful extension of an inventory search. This court disagrees. Interesting. Finding that the cataloging and photographing of the notebook was a valid part of the inventory search. Man, I'd be doing some FOIA. Nor does the evidence suggest that the purpose of examining the notebook was, quote, investigative, end quote, rather than conducting an inventory. That the officers photographed every single page demonstrates the purpose was to catalog rather than investigate. Man, judge is always right? Man. And Burns was careful to document every page of the notebook to protect against claims of damage or tampering. The Pennsylvania search warrant. The people argue that the search warrant for the backpack obtained at the end of the day after the search of the McDonald and inventory searches at the station provided an independent source for the evidence. Okay, that's the eventual discovery that I talked about in the motion. However, the presence of a, quote, independent source, end quote, does not, quote, automatically immunize an initial warrantless search, end quote. They're talking about this case, Arno. He says here, Altoona police relied partly on the evidence itself recovered from the backpack and information given to them by the NYPD after searches had occurred. Therefore, the independent source doctrine does not apply. And to apply it under these circumstances would improperly vitiate the warrant requirement. All right, here comes Miranda. Defendant's statement to law enforcement. A defendant's statement obtained through custodial interrogation and without Miranda warnings must be suppressed. However, quote, any statement given freely and voluntarily without any compelling influences is, of course, admissible into evidence, end quote. Volunteered statements of any kind are not barred by the Fifth Amendment. The Miranda safeguards do not come into play unless a person in custody, quote, is subjected to either express questioning or its functional equivalent, end quote. To determine the admissibility of a statement given without Miranda warnings, the court must determine, 1, whether the person was in custody, and 2, whether the police questioning constituted interrogation. To determine custody, the court might find that 1, a reasonable person innocent of any wrongdoing would not have believed that he or she was free to leave. We saw the pictures in the video. And 2, there has been a, quote, forcible seizure which curtails a person's freedom of action to the degree associated with a formal arrest, end quote. Now, those are New York citations. Interrogation is defined as any questioning that is reasonably likely to elicit an incriminating response. During the initial interaction at the McDonald's from about 9:29 a.m. to about 9:47 a.m., I find the defendant was not in custody. Only 2 or 3 officers approached or spoke with the defendant. The interaction occurred in a public setting where the defendant was eating breakfast and there was no indicia of custody. The officers did not display their weapons, employ physical restraints, or engage in any conduct that would lead a reasonable person innocent of any wrongdoing to conclude that he was not free to leave or under arrest. Wow. I think that's lenient. Therefore, any of the statements made during this period will not be suppressed. Oh, okay. He says, sorry. The analysis is different. However, once more than 8 officers arrived at the scene, and surrounded the defendant, such that a reasonable person would not believe they were free to leave. I would like to see the body cam prior to the rest of them arriving. But the officers positioned themselves in a manner that effectively encircled the defendant and controlled the immediate area, creating a police-dominated atmosphere. Their presence and positioning significantly restricted the defendant's freedom of movement and foreclosed any avenue of departure, right? Under the totality of the circumstances, the court finds, as established by the video evidence, that at this point at about 9:47 a.m., the defendant was in custody. Therefore, the responses given to the officer's questions that were interrogation or the functional equivalent, including Fox asking why the defendant had lied about his name, Fry also asking why he lied, Fox asking if he had a fake ID, will be suppressed. Yes, that's a crime. Okay, if lying to the police is a crime, talking about lying about it and a false ID is a crime. However, the responses to Detweiler's and Fry's questions about defendants, it's funny, it's Fry, there's Fry challenge, about the defendant's real name, date of birth, and his middle initial will not be suppressed as they are admissible as pedigree information. Number 10, additionally, defendant's questions and statements to the officers, quote, calling a couple more cars, end quote, and quote, this is Puffy Jacket, I'm not very big, end quote, and quote, can I ask why there are so many cops here, end quote, will not be suppressed as they were spontaneous and not in response to police questioning. You know why? Who knows? We don't know. We're just speculating. Okay. After defendant was given Miranda warnings at 9:48.32 a.m., he shook his head when asked if he wanted to speak to the officers, and again asked why he had a fake ID. Defendant responded he was going to remain silent. These responses are of course not admissible. 11. Similarly, defendant's response to the question about whether there was something in the bag, just going to remain silent, is not admissible. Right? Because that could be prejudicial. Right? What would you think if you were a jury hearing that? Well, what did he say? I'm just going to be silent, right? Okay. He says, however, his responses to being asked to stand up for a frisk if he had any weapons on him and responses to follow-up questions about the pocket knife are all admissible as safety concerns and related questions. Yes. Terry, stop. Hopefully I'm not blowing you guys' ears out. Sorry. Further responses to questions from Fox about his name, to McCoy about where he's from, and to Burns about his age are all admissible as pedigree information. Defendant also made statements to 2 Pennsylvania correctional officers, Matthew Henry and Thomas Rivers, who were monitoring while he was being held at the correctional facility. Both Henry and Rivers testified at the hearing, and I find them to be credible witnesses. Henry's testimony was uncontroverted, meaning it's not controversial. It's pretty straight that he did not ask the defendant any questions or attempt to elicit any information from him, and I find those statements to be spontaneous by the defendant and therefore admissible. Officer Rivers and the defendant engaged in casual conversation on various subjects. Again, the defendant's statements were not made in response to questioning or interrogation, and I find those statements to be admissible as well. This constitutes a decision and order of the court. So, now we have to figure out what information, what did we lose? What did we lose? If we're the defense, what did we lose? Did we lose the cell phone? Okay. It was the cell phone. Where's his ruling? Hold on. Okay, so the magazine, cell phone, passport, wallet, and computer chip is gone. So, depending what's on that, I mean, that could be huge. Well, the gun was loaded, right? They said, if I remember, the gun was loaded when Wasser was unloading it. So, were the bullets in the gun? I'm assuming this magazine is a spare magazine. If the bullets in the gun are the same type of bullets alleged to be the shooting bullets, if they were engraved or anything like that, the gun is still in, right? So that could be problematic. And if the bullets were engraved, if the gun is a completely different kind of gun, and I don't know much on this case, I don't know, how the magazine would fit in, the cell phone, location, chat, there's a wealth of information that could be on the cell phone, the passport, wallet, and the computer chip. I'm not sure what's on there. So we don't know what's going to happen on this case now. This just came down again. Mangione is innocent until proven guilty. These statements are made by the judge and the attorneys in the case. This is not a formal opinion. It's just feedback, speculation, commentary, teaching moments based on what we're seeing, what is going to happen here. So let me know below if you've liked this, what you'd like to see, if you want to go into the particular pleadings, if they're available. I don't know if they're available about the court hearing, or do we want to see if there's anything on the cell phone or any a thing that we can find there. Okay, because I'm assuming they pulled the cell phone, and there might be some motions and things around the cell phone and the computer chip. But let me know. Thanks for being here. I appreciate all your help and support, and I will see you on the next video.